Let's look at then, with that application, what you can consider and should consider. The statements to the media and the declaration of the foreperson. The foreperson's statements to the media, it's all in our motion. I know you read it. The intent to kill is improbable to us. The jury did not believe Dr. Konig intended to kill Ariel Konig from her affidavit. From her affidavit, I believe Dr. Konig was not guilty of attempted murder. From her affidavit. Sworn statement that that's why we did this, because if there's any doubt she said that, by all means, go interview her, which they did. And I don't know how they went about it that made her uncomfortable to talk to them and didn't record it. And all, but now, in a report that's generated the day after a reply is due, or at least produced well after, but the point is she verified that what was in that affidavit was true. So what does that mean? She has told the prosecutors that what she said, I believe Dr. Konig was not guilty of attempted murder, that's a true statement. Juror number 3, I don't know if he was trying to kill his wife, but he had the capacity to kill his wife. Now here's the thing. Here's the part I frankly don't understand. I'm not so sure what the prosecutor is saying today about this, because the opposition was filed when it was filed, and presumably they meant what they said in their opposition. And let's look at what they said in their opposition about what you can consider. And it's on page 17 of their opposition that was filed by the state. Obviously, we have duties to the court when we file things, that we mean what we say. What evidence, this is their words, what evidence is left after HRE 606B is applied correctly is Exhibit D and statements number 1, 3, and 4 of the foreperson's affidavit. Statements 1, 3, and 4 of the affidavit. Statement 1, I was the foreperson. Statement 3, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. They are conceding in their opposition filed in this court that you can consider that properly under 606. Statement number 4 from the affidavit. I did not believe that Dr. Konig had an intent to kill his wife during the incident on the Polipuka Trail, and I believe he was not guilty of attempted murder. They concede you can properly consider that under 606. And at first I thought, is that a typo? And then I read what's before and after, and it's clearly not a typo. They believe that the application of 606 precludes, as I've talked about, mental deliberative processes, but doesn't preclude, an objective irregularity, result-oriented kind of comment. So they themselves say you can consider that. So let's summarize then with what they concede, what can and be properly considered, even by their own admission. Again, the intent to kill is improbable. Did not know if he had an intent to kill. Jury was not unanimous as the intent to kill, and a foreperson believed she believed he was not guilty of attempted murder. So, if you can consider, and because you can't consider all of that, the verdict just cannot stand. It just can't. It's undisputed how your instructions worked and how the law worked. Nobody, I think, is disputing that. There must have been a unanimous agreement to guilty on attempted murder before they could even consider extreme mental emotional distress manslaughter. We all know that. We all know that. We have a juror saying, I didn't believe he was guilty of attempted murder. I didn't believe he had an intent to kill her. So, and if it was not unanimous, the instructions then direct them to go to the assault charges, which did not happen. And, I think we can all agree that even for us lawyers, the instructions are complicated. So I'm not faulting the jurors. I mean, they're human, they're trying their best, but mistakes happen. Misunderstandings happen. And that's not a failure of the system. What's a failure of the system is when we learn about that if we don't take steps to correct it. And that's the way the law works. And if there is an irregularity, there is an irregularity and a fatal flaw in the verdict, because it was not a unanimous verdict they did not follow the law the way it was given to them. We talk about how at best, if you look at juror number 3 and what he says, at best that's a non-existent offense of attempted reckless manslaughter from the Stanley case, right? I don't believe he had intent to kill, but maybe what he did had the capacity to. That's reckless manslaughter, and there is no such thing. And I guess I'd ask you to consider this. I mean, I know this isn't exactly what happened, but it's pretty close. Let's say a jury, and it's an important case. Obviously, he was facing life in prison, right? And let's say someone's facing life in prison, and a verdict comes back, and the juries find the defendant guilty of, let's say, murder. Let's say murder first, where he's going to be life without parole, the harshest sentence in our state. And then the foreperson walks out of this courtroom, and then there's cameras there, and the foreperson says, at her own volition and no prompting, well, you know what? Yeah, at the end of it, 6 of us thought he was guilty, 6 of us thought he was not guilty, that they didn't prove it, but we just returned a verdict of guilty. I have a hard time believing that our appellate courts would let that stand. I mean, I would have a hard time believing this court would let that stand. I mean, that would be absurd. And that's essentially what they're asking you to do. Maybe not to that extreme, but pretty close. Pretty close, when we know a juror has said they were not unanimous as to a required element, and she herself has said she didn't believe he was guilty of attempted murder. Meaning, at best, it was 11-1, which that's not what she was saying, but we can't just ignore this. We can't ignore this, and we have an opportunity to fix it. Just to address some of the prosecutor's arguments, we're not invading the power of the jury to act independently. I'm not sure what they mean by that, but we're not. That's the part, the independence of being able to think through things, consider evidence this way, give credibility, weight that way. Yeah, that's their independent right. What they don't have a right to do is not follow the law. That's different than invading their power to act independently. We're not invading jury secrecy. They came out and she said what she said. When you allowed us to talk to her, she said what she said. We never did, nor will we ask her. We didn't ask her, why did you, how did you end up over there? We're not invading their secrecy. We're not invading their freedom to deliberate. We're not harassing any juror. All of these statements were made freely at their own will. So, I mean, that was the gist of a lot of their opposition, is these policy reasons behind this. We're not violating that. And then again, it's a balance. Yeah, we don't want to inconvenience any juror, make any juror feel uncomfortable, but we also want to get it right and make sure that there was not an illegal verdict under the Constitution. For these reasons alone, a new trial must be granted. The text messaging, and again, we objected to this being broadcast nationally, but it was allowed. And, then a commenter on one of these live streams commented during deliberations, before the verdict was returned, I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. And there's a couple of significant things about that. It says, I've been texting with, which infers a conversation, multiple texts. I've been texting with one of the jurors. It infers an ongoing conversation. The use of the term count 3, they're going for count 3 attempted manslaughter. No one in this courtroom ever referred to anything as a count. Nobody said the lessers is count 2, count 3. Nobody said that. We pointed out how in the statements to the media, one of the jurors did use the term, we went through all of the counts. So one of the jurors in the deliberation room, apparently the term counts was being used, even though we didn't use it in this courtroom. And now this person is using the same term. They're settling in on count 3. What else do we know about that? On the verdict form, although it was not indicated as counts, the third option, which would be, if you wanted to consider them counts, count 3, was extreme mental emotional disturbance manslaughter. So he said, and presumably, I don't think the verdict form was even publicly accessible at that time. So some guy, wherever he was, and somewhere on the mainland, would have never known that count 3 was extreme mental emotional disturbance, or at least the third option in the verdict form. But he used that term. He didn't just say they're going for attempted manslaughter. He said they're going for count 3 attempted manslaughter, using the same reference to count as a juror did to the media, and picking the number on the verdict form that was emailed. And then lastly, that he correctly predicted the verdict. I mean, that, and there's case law we cited about the import of when somebody correctly predicts something, you know, how it provides an indicia of reliability. So there is indicia of reliability to lead to concern because of that. And I don't believe it is something where we can say, maybe it was just this or maybe it was just that. Remmer versus United States, the United States Supreme Court case. Private communications with jurors during trial concerning matters before the jury are presumptively prejudicial. Presumptively prejudicial. And the burden rests heavily upon the government to establish harmlessness. That's our United States Supreme Court. Our Supreme Court, 76 Hawaii 172, State versus Foreperson. Once a defendant makes a prima facie showing that an improper influence may have affected the jury, prejudice is presumed. Prejudice is presumed. And the state must establish beyond a reasonable doubt that this misconduct did not affect the defendant's substantial rights. From what we've submitted and the arguments we've made and the inference and the indicia of reliability related to count 3, accurately predicting it, the timing of it all, we've made a prima facie showing. Burden shifts to the state to establish beyond a reasonable doubt that it did not happen or did not affect his substantial rights. What did the state do to meet this burden? Nothing. Nothing. It doesn't appear they went and, you know, you just saw they have investigators that work for them full time. Probably many of them. And that's why we put the burden on the government, because they're the ones with the resources. They're law enforcement officers with the right to subpoena things, to get search warrants, to interview witnesses. You know, if they believe there was tampering with a juror, that could be a crime. They could, you know, call people to the grand jury. There's any number of things they can do to meet this heavy burden of trying to show beyond a reasonable doubt that my client's rights were not affected. They did none of that. Call your investigator. Tell us what you did to figure this out, because I would assume you'd want to figure this out. I'd assume you'd want to know, in your role of seeking justice, not just convictions, did this happen? This is concerning. We should look into this. It's not only our burden, but it's our ethical duty to, if there was misconduct here, we want to know. What did they do? Nothing. I don't think they wanted to know. I think they were afraid of what they would have learned. So a prima facie showing has been made, and they have done nothing to meet their burden to establish beyond a reasonable doubt that this misconduct did not affect my client's rights. Prejudice is presumed. We don't need to show harm. Prejudice is presumed. State versus Furatani. Remner versus United States. Presumptively prejudicial. I come back to what I said earlier, Your Honor. This motion raises important questions about what you are okay with in your courtroom. And I mean that respectfully. Do the jurors have to follow the instructions? The jury instructions, I'm not going to go through all of them, but you know, many of them directly call into question what happened here. You are the judge, this is number 2, page 2, from the instructions. You are the judges of the facts of this case. You will decide the facts, what facts were proved by the evidence. However, you must follow these instructions even if you disagree with them. They're told they have to follow the way the law works. Page 16 of the instructions. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required state of mind, as these instructions specify with respect to each element of the offense. That's the law. They took an oath to uphold that. We now know that that was not a unanimous finding as to the requisite state of mind. We talked about the elements on page 19 and what was required before they could unanimously find guilt on the attempted murder. We talked about how one juror said she didn't believe he was guilty of attempted murder. And then lastly, as to the text messaging issue, one of the last instructions that is given to them on page 43, during your recess from deliberations when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not reveal to the court or any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and has been received by the court. It's one of the last instructions you gave them, which raises the question, do jurors need to follow the law in your courtroom? Of course they do. Of course you're not okay with that. It would be an incredible coincidence if somebody, prior to the verdict, used the term count when nobody in this trial used it, and then the jurors used it, that they would know it was the third option on the verdict form, and that they would know and accurately predict the verdict. It would be an incredible coincidence. And we can't, there's too much at stake to just assume that it was some lucky guess. We have established a prima facie showing. There's presumptive prejudice. They could have done any number of things to try and meet the burden to show that it didn't happen. In closing, Your Honor, I'll say this. I'll be the first to admit, this is not ideal. I get it. I don't envy you being in this position. It's not ideal. It's not any of our faults. It's not your fault, surely. You ran a great trial. When I say it's not ideal, I mean this was a long time-consuming trial, resource-consuming trial, energy-consuming trial. And at the end of it all, for this to happen, nobody wants that. It's not ideal. But these things happen. It's a human system. Jurors are human. I'm not faulting them. It's in terms of the application of the law and the way it flows, if you find this, you go here, if you find that, it's confusing. Jurors are human. And again, I'll just say it again. The error that occurred here on the part of the jurors, inadvertently or advertently, it's not a failure of the system or a failure of how you ran this trial. This trial was run, that was not the issue. But allowing a verdict to stand. Yeah, well, I'm just, but I'm just saying, like logistically, obviously we disagree on certain legal issues. I'm just saying logistically, it was run well. And I'm just saying, sometimes these things happen despite our best efforts. But allowing the verdict to stand with clear evidence that it was reached in error and not taking this opportunity to correct it, that would be a failure, and that would be wrong. So we ask that you do the right thing and grant a new trial. If 606 and the language that is used there, this is exactly the situation. This is why the balance was struck when they drafted that rule, was to be able to take action when there are irregularities like this. And we cannot be dismissive of what was said and what we know about the texting. We can't. We have to err on the side of constitutional rights here, and it's all it is. It's just a new trial. We're not. It's all it is. So we appreciate your time, and we're asking that you grant our motion.
I disagree. So in Hawaii, and if you want to specifically talk about misunderstanding, that would be State v. Laeta.
I'm sorry, State v. what?
State v. Laeta. It's on page 11 of my memorandum. The proffered affidavit, and just for a bit of background, State v. Laeta was a case involving a issue that came up at a trial where one juror raised an issue where he didn't understand the proceedings in the trial. The juror was voir dired by the trial court judge.
I asked the question of instructions. That's one of the spirit points of the defendant's arguments is they just didn't follow the instructions. They didn't understand it. Or they ignored it. Some combination of those things.
I have Ninth Circuit then for you, Judge Vasquez v. Walker. Started on page 12 of my memorandum. The court noted the trial judge had read the instructions. The jury had an opportunity to ask questions to clarify, which the jury did in this case as well. The jury knew how to use the communication forms, and in fact did send communications, but did not ask any clarifying questions of the court. The Alaska Supreme Court in Myers v. State, clearly written instructions may be instructions may be misinterpreted by a juror is simply one of the hazards. The misinterpretation is an inquiry into the juror's mental process, and getting into that would violate 606B. So I do think that there has been a lot of case law about these issues, about misunderstanding, mistake, in Hawaii and other states that show that this is not a reason to grant a new trial. Taking a step back, the big issue here is, of course, what started all of this is the statements to the media by two of the jurors. In those statements, the jurors are asked to explain how they reached their verdict in this case. There could not be a more heavy indication that what they're talking about is their mental process in coming to their verdict. Now, one of the exhibits was cut off for the question. The second exhibit, involving the foreperson, she was directly asked, how did you get to manslaughter, or why manslaughter? And that's when she started to explain. So these statements are directly the jurors sharing their mental processes. This is not an objective misconduct. This is not anything other than clearly violating Rule 606B. And I don't know how to put it more clearly than what's actually in front of the court. I do want to point out that defense, in their reply memorandum, also stated that their motion is predicated on this inadmissible evidence. Dr. Konig relies only on the portion of their statements that identified the jury's determination underlying the verdict. It's on page 7. The statements underlying the verdict, the reasons for how they got to the verdict. That's what we're talking about here. All of this comes from those statements. Taking a minute to talk about the application of 606B. I did do a application of 606B in my memorandum, and I did indicate which proffered evidence that would potentially, or that the court could consider under 606B. I want to be clear, though, when I say that statements 3 and 4 can be considered by the court. Statement number 4 is all in the past tense, despite being misstated as a present sense statement by the juror, by the foreperson. We don't know when the foreperson believed or didn't believe this, based on the affidavit that the defense prepared for her. It's completely unclear. So I don't have enough information to tell you whether this violates 606B or not, because I don't know if this is in deliberations, if it's sometime before deliberations, if it's a statement or a state of mind she had after deliberations. The information is just not contained in this statement. If the statement is applied as her mental state during deliberations, then it would be inadmissible. But I can't. Then it would be inadmissible.
Okay.
But I can't say that because I can't assign anything further than what is actually written on the paper. And the foreperson is not here to testify as well. Not here to face cross-examination about the circumstances of this, not here to face cross-examination about who prepared this for her, whether she understood it, whether she had legal representation, what statements were made to her in the process of signing this. All these questions have been unanswered by the defense failing to present this witness, and more. So when I say that the court can consider this, yes, you can. It just has no relevance to the court's determination because there's no time assigned to it. With regards to statement number 3, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. Again, there's no time. There's no time element to what this statement is. And there's also the issue of polling. The purpose of polling is to let jurors who have lingering doubts, that have a doubt later on or that have second thoughts. The purpose of the polling is to let them voice those. It's kind of a speak now or forever hold your peace kind of moment. And that happened in this case. And every juror said they agreed with the verdict as it was read. So, yes, you can consider statement number 3. It just doesn't have any effect because the jurors were polled under oath when they swore that oath to return a verdict according to the law and the evidence. They were polled. They all said they agreed. Overall, what we're asking here, Your Honor, is not to deny this motion on a technicality. And that's the reason that I spent so much of my opposition going through the history of jury trials, the history of jury deliberation, jury secrecy, the history of all this stuff, because it's fundamental to the jury trial system that the jurors don't have their internal deliberative processes examined, brought up, testified to, cross-examined on. All of those things stymie the entire purpose of jury trials. Well, the court sounds somewhat reluctant to consider the effects. There is a chilling effect on future trials if we start opening those doors. There's a massive chilling effect. Any juror in a case against somebody who's potentially very popular publicly, a sports figure, somebody like that, any juror would be pressured knowing that their verdict could be attacked, that their thought process in reaching their verdict is not secret. It's essentially what we're asking, what you're being asked to do is to break the promise the judiciary made to these jurors. We bring these people in. We ask them to serve, to sit for a month, and they're told that their deliberations are secret. And it is an incredibly, essentially, if you do not believe in secrecy of deliberations, you do not believe in jury trials. As simple as that. So this is not a technicality. This is something where there has been a large body of case law of similar issues in Hawaii, of the exact same issue in other states and the Ninth Circuit. And all of that case law shows that this is inadmissible. Even defense's own admissions that what they're seeking to do is to get into the mental process. I know it's stated several times throughout defendants' original motion and their opposition that they don't want to, that that's not what they're trying to do. But in fact, that is what they are looking at. They are looking at the internal deliberative processes of how these jurors came to their verdict. It's not objective. The objective misconduct examples are all throughout my memorandum. You know, when a juror brings in outside evidence to the jury room, objective misconduct. When a juror makes a decision and introduces their own life experiences similar to a victim, objective misconduct. But what all those cases are also very clear on is the court cannot consider the effect of any statement made. Right? So objective misconduct is admissible. That's not what we're talking about here. We're talking about how the jurors got to their decision. We're talking about trying to get into their heads. And that is hugely problematic. And frankly, it is inadmissible for not just policy reasons, but because it's fundamental to the jury trial system in this country. Moving on, getting closer to the end here, Judge, to the YouTube comment. It's an anonymous YouTube comment. The defense is citing the U.S. Supreme Court case, I believe Renner. In Renner, the contact between the outside person and the juror was known. The juror reported it to the court. There was an FBI investigation in that case. There's an FBI report prepared. It's clearly distinguishable from this case where there is no confirmation of juror contact. The specter has been raised, yes, but it is defense's burden to actually make that prima facie case, and they haven't. So we're citing a case with a completely different set of facts and trying to apply it to the same way, and that's not what we have. What we have is an anonymous internet comment. Anytime there's a high publicity case, anytime there's a case that is on the internet, which there are certainly going to be more to come in the future of any jurisdiction, anytime somebody makes a comment claiming to have inside knowledge or claiming to know something else, anytime that happens, what defense is saying is that should be an automatic granting of a new trial. And that's not true. Lastly, you should consider the actual context of this statement on its face. There's no statement indicating that there was communication, anything other than potentially somebody leaked the verdict. There's no indication of any talk about discussing with the juror how they thought about things, convincing the juror to vote one way or the other. There's none of that. So for that reason as well, there's no prima facie case. So overall, what defense is asking you to do is to get into the juror's mindset of how they ended up at the verdict they ended up. That's what this is all based on. And although they can say it's not what they're looking for, unfortunately, factually, it is. That's how these statements came about. That's how these things were raised. And that's where we're at. And that's why 606B applies. These statements are inadmissible, and the court should deny this motion.